Texas ranks first in the number of people executed by the state. Recently, a Houston judge questioned the constitutionality of the death penalty, reopening a debate on this subject. Has the death penalty been an effective deterrent and a just punishment for unspeakable crimes? Or, with DNA testing exonerating inmates across the country, has capital punishment proven to be a grave mistake? Tonight, the state of capital punishment. I'm Ernie Manous, and this is Houston 8. Joining us tonight are Aaron Street partner, Baker Botts LLP, Robert Talton, lawyer, Woodfill Pressler LLP, and Dr. David Dow, distinguished professor, University of Houston Law Center, and founder of the Texas Innocence Network. Welcome to all three of you. First of all, the first thing, when you bring up the death penalty, people have opinions one way or another. And oftentimes a discussion like this goes nowhere because you can't really move where people's beliefs are. But David, if I understand correctly, you used to be in favor of it and now are not. Is that correct?
That's true. That's true. But I don't really know if I changed my mind for the type of argument that death penalty opponents, or for that matter, death penalty supporters, might make. I just changed my mind because I gained a familiarity with the process by virtue of working on a lot of death penalty appeals. So the beginning of my changing my mind was, I think, coming face to face with the difference between the way the death penalty actually works and this idealized idea of a death penalty that I had in mind before I started working on the cases.
Okay, Aaron, what we started with the show talking about in that lead in there was about what happened in Judge Fine's courtroom. Can you fill us in a little bit on what was going on there and how he was calling the death penalty into the spotlight?
Well, there was a murder prosecution, capital case, and the judge decided that he would hold a hearing before the trial on whether the death penalty itself in Texas is being constitutionally applied. And the Court of Criminal Appeals has now said that it was procedurally improper to hold a trial on the entire death penalty in Texas before even holding a trial in the individual case.
So they really ruled on procedure, not on the death penalty.
That's right. Although we know the members of our Court of Criminal Appeals are all in favor of the death penalty, at least as a blanket matter. They favor it as a policy. They don't believe it's unconstitutional.
And Robert, this is not the first time that people have questioned the constitutionality of the death penalty.
It is not. That happens probably almost annually.
Yeah. And I just want to start with, if there is, and I guess that they're citing the Eighth Amendment was what they were looking at, about cruel and unusual punishment, and it's gone back and forth. How do we justify, and any of you can answer this, how do we justify putting someone to death as not being cruel and unusual?
Well, the easiest way is the text of other parts of the Constitution. For example, the Due Process Clause says that no person shall be deprived of life without due process of law, which leaves the implication that someone can be deprived of life if due process of law is applied. Due process simply means a fair trial.
But the question, I guess, that's coming up is the way that the death penalty is being put out there fair? Is that
yes, one
correctly?
Of the arguments in the Green case, in fact, really the principal argument was that there are certain categories of cases where we know that we make mistakes at a really astoundingly high level, in particular in cases involving eyewitness identification, and the Green case is an example of that. There's a terribly high error rate, and it's in some ways counterintuitive because most people trust their own eyesight and they think that if they saw something, that's what happened. But all of the evidence indicates that eyewitness testimony is extremely unreliable. And so what Green's lawyers were arguing was, apart from the general question of
just
whether...
Just for clarification, the Green case is the one that Judge Fine was hearing.
Correct.
So.
The Green case is the one that Judge Fine was hearing. And what his lawyers were arguing was, aside from general questions about the constitutionality of the death penalty, we shouldn't be having the death penalty in cases like that one, where the principal evidence is eyewitness identification, because we've learned over the years that the risk of error is simply too high, and that if the risk of error is too high, then we can't confidently impose a death penalty in a case where that's the type of evidence that supports it.
But as I understand, too, even if you find out that there were errors in certain aspects of it, the jury verdict still holds initially, correct?
Initially it does. Any capital murder case where a jury has returned a verdict, you have an automatic direct appeal. And so that's going to hold as far as that. And it's appealed to the Court of Criminal Appeals, not to the Court of Civil Appeals, or what we used to call the Court of Civil Appeals, Court of Appeals for fact issues. But it all goes straight to the Court of Criminal Appeals. In addition to that, you also have what's called your writ of habeas corpus under Section 11.071, I believe. David would know it better than I. I helped write it, but it's been a while. I think we did it in 95. And the thing at that time was to run it together. And you have balancing issues on both sides, whether you agree or disagree with the death penalty. I think both sides want it to be fair, whether you're for it. If you're for the death penalty, then you want to make sure that it's fair. Eyewitness testimony, as David's talked about, eyewitness is how many of the crimes are done. Even though we now have DNA, which is an issue that we'll discuss, I'm sure, today, that you still have the eyewitness. It kind of goes back from the biblical times. That's how it started, actually.
If I understand correctly, too, and Kevin and Judge Fine was saying that full-fledged accounting of safeguards of the procedures available used to convict and execute inmates in Texas is what he was challenging. That the procedures we're using make it possible for mistakes to be made, and if mistakes can be made, then you shouldn't be using this. Correct?
Right. There were really two parts to that the lawyers representing Mr. Green were making, and the first was that there are many opportunities for mistakes, and eyewitness identification is one of the large opportunities for mistakes. And then the second piece of their argument was that many of these types of mistakes are mistakes that can't be fixed on appeal, because appeals focus on different types of issues, and they don't focus on the type of issues that they wanted to raise prior to the trial. So they were essentially arguing that it was the right time to make this argument before the trial even started, because there wouldn't be an opportunity to make the argument later. Whereas the district attorney's office was saying, look, we're not going to talk about the substance of these issues right now, because the appropriate time to raise them is later. And so I think really the disagreement in that case was not really about whether mistakes are made, how frequently they're made, any of that. The disagreement in that case turned on whether the right time to make that challenge was before the trial or after the trial.
Aaron, when is the right time then? I mean, how do you, if in the Green case no one was given the death penalty yet, so you can't really challenge what hasn't been done. Once, if Judge Fine should take it all the way and Green is convicted and does get the death penalty, then can the lawyers remount this exact same challenge?
Well, they can, but as David pointed out, it's very hard to overturn a jury's factual findings about something like eyewitness identification. But I think this question of timing goes really to who should decide. And in a republic like we have, the legislature is the one that decides these kind of policy issues, so long as there aren't any constitutional problems. And I think there's a real problem with saying that certain types of evidence are so unreliable as to be unconstitutional, because that would throw out the entire criminal justice system. It would be just as unconstitutional to convict someone of misdemeanor theft on eyewitness as it would be to impose the death penalty. So I think that just shows that this is the kind of thing that a legislature has to sort out and not a judge.
So then where does that happen? Is that in the election process, people running on it, feeling the feeling of the community? Is that where it would happen?
Well, it could very easily. Just in the legislature in general, I sat 14 years on the House of Criminal Jurisprudence, and these issues came up, and usually it will be in the legislature. And this last election pretty well will tell you where most of those guys are, at least in the House and probably in the Senate. The Senate in Texas kind of operates like the Senate in the U.S. Congress operates. But the House this time will be a pretty conservative House committee.
So we really probably wouldn't see any change. And also, I guess public opinion is around 70% still in favor of the death penalty, correct?
Well, in the abstract, if you ask people if you ask them in the abstract, do you support the death penalty, then close to 70% says yes. If you say that there's a choice between a death sentence and life without parole, then it basically becomes a coin flip. It's about 50-50. So it's a question of what is the alternative.
You bring up life without parole, and in some research that was done for North Carolina, a report that was filed, they said that to give someone the death penalty, let me reword that. If you abolish the death penalty in North Carolina, it would save the state almost $11 million annually. If that is in fact true, then an argument that I've often heard is that it is more cost effective to put someone to death than give them life imprisonment. But this would fly in the face of that.
Yeah, I've never heard anybody actually make the argument that it's more cost-effective to execute somebody, because in every jurisdiction where the issue has been studied, it costs quite a bit more to execute somebody than to keep him in prison for life, generally because the cost of a death penalty trial is much higher. And it relates to a point that Aaron was making a moment ago where he said that you might have a problem with the entire criminal justice system if you get rid of one category of evidence. And there's certainly a logic to that. What somebody like me would probably say is that death penalty cases are different because we might be more willing to tolerate a risk of error if the maximum punishment is 5 years, 10 years, and we're less willing to tolerate the risk of error if the maximum punishment is an execution. And because I think many people have that view that we really don't want to make mistakes in death penalty cases, even if we're making them in other types of cases, that raises the price of death penalty trials. And death penalty trials are quite a bit more expensive than non-death penalty trials.
That information, though, seems to be out there. The DNA that's being, and we'll get to DNA in just 1 second, but the DNA exonerating people, things like that, people are aware of that. So then why is it still 70% in favor of the death penalty? People, I assume, thanks to all the coverage he gets on TV, realize mistakes are made, yet they still support it.
I think that's an excellent question, but what I would say is that that's maybe focusing on the wrong fact. The fact is that 70% of the people support the death penalty, but if you look and see what's happening in individual trials, you have many fewer death sentences. In 2010, in Texas, we just had 8 new death sentences. Now that compares, in the 1990s, there would be 40 or 45 new death sentences a year. So we went from 40 to 8 in the span of 15 years, which is a very significant decline. And so I think what I would say is you might have 70% of the population saying that they favor the death penalty, but when you take those people and you put them on a jury in an actual case, they're in fact returning death sentences at a dramatically lower rate than we were 15 years ago.
The decline in death sentences suggests to me 2 things. One is that our legislature has enacted the option of having life without parole. So while we certainly have a conservative legislature, it's not one that is deaf and blind to concerns of unfairness in the death penalty. And many juries have been choosing that option. The second point that shows to me is that juries are reacting to this kind of evidence that's coming into the public sphere about exoneration. But that, to me, points to trusting juries and trusting the legislature to sort out these problems rather than having a judge do his own inquisition on whether the death penalty is constitutional or not.
Robert, let me go to you about bringing in the DNA. If, in fact, we are seeing that there have been, 260 some odd exonerations across the country already, how can we still support a death penalty when we know for a fact that this many people were sitting on death row that were, in fact, not responsible for the crimes? Well, how can we look at our history and not realize proportionately the state must have put quite a few people to death that were innocent of these crimes?
Well, we don't know that. What you did is when those people were convicted, you had the best evidence that you had at that time.
Right.
As you know, the DNA methodology has been improving for many years, and I think it was like 2001, if I remember right, when we finally got the DNA and put it into a system that we could check it. And most judges, and David or Aaron can probably speak to it more so, but if you have good concrete evidence when you raise the issue that there's DNA that may prove to exonerate me, most judges are going to do that. So they're going to allow you that opportunity. I think we may have passed a law to allow that, if I remember right, to allow them to do that and check it and see. And I think President Bush back in 2000 or thereabouts, 2001, did that. And they checked it and found out that, it was him. But you can get that done in the DNA. And it's just, as we go along, we have better methods of checking the DNA. And that's really the thing. It's what you have at that time. Whereas back in the 80s, when they were doing it, it's basically eyewitness.
Right.
Yeah, I'd make a slightly different point, which is that most of those 250 DNA exonerations were not death penalty cases. Almost all of them are rapes or sexual assaults, which is how you have the biological material that then results in an exoneration a number of years later. Conversely, most death penalty cases are not DNA cases. It used to be in the 90s that most death penalty cases in Texas were so-called felony murders. That is, it was somebody who was robbing a convenience store and killed somebody or killed multiple people. And those are generally not DNA cases. So I think really the question is there anything that we can learn from those DNA cases that is applicable to the death penalty cases where there's frequently not any DNA? And one of the things we were talking earlier about eyewitness identification, I mean, one of the things that we've learned from the DNA exonerations is precisely how unreliable eyewitness identification is. If you take those 250 DNA exonerations, in more than 70% of those cases, there was an eyewitness who identified the person, who we later find out is absolutely 100% innocent. So if in 70% of those cases you have an eyewitness saying, I'm positive it's that guy, the jury believes the eyewitness because jurors tend to believe people who trust their eyes. And what we've learned is that's a mistake. So the question, I think, really is, what do we then do with that piece of information that we've learned from the DNA exonerations when we're talking about the death penalty? How do we apply it in the death penalty debate?
Well, Aaron, back to something you were saying earlier then. Okay, if you throw out eyewitness testimony, how are you doing trials? I mean, so much of what we assume is from what we see, how we receive the information that surrounds us. So if that's not accurate, what happens to the criminal justice system?
Well, that's a good question. And I think it's an important point that David made, that vanishingly few of these exoneration cases are death penalty cases. So I don't see evidence of a crisis of people being wrongfully convicted and placed on death row. It's mainly been sexual assault cases. And I think...
but if, just to argue it, if in fact it is happening in one grouping of crime and the DNA is proving that there were mistakes made in that group, wouldn't you assume then that there were mistakes being made in others? Just because you don't have the DNA to exonerate these people, can't we extrapolate that if these victims or these people that have been accused are getting off because mistakes were made, the same must be true in other types of crimes?
I don't think you can extrapolate that without evidence. I mean, there are a lot of death penalty cases are DNA cases nowadays, and a lot of cases, just cases that I've been aware of, have been capital convictions, and the DNA is tested because the DNA technology is now available, and the DNA reconfirms the eyewitness testimony. So there are a subset of cases we could look at that are death penalty DNA cases, and in fact, almost all of them have confirmed that the death penalty was correctly given in those cases.
So is it safe to say that we're playing kind of catch-up with old cases, but currently we're moving forward in the right direction?
Well, maybe Aaron and I just have a different definition of what the crisis level of mistakes in death penalty cases is. I mean, you know, we've had nationwide several hundred people who've been exonerated from death row. The reason that then Governor Ryan declared a moratorium on the death penalty in Illinois is because in the same amount of time in which Illinois had executed 12 people, 13 had been exonerated. I mean, they were batting less than half. We've had, you know, a couple of score of people who've been released from death row in Texas. So I mean, now it's true that there are 350 still there. There are 450 who were, you know, executed. So as a percentage of that total, you know, universe, it might just be 3-4%. So it's, you know, you're doing pretty well if you're batting 97%, 96%. But when you think about the cost that is borne in that comparatively small universe of cases where you get it wrong, I think it's a high enough cost that I would say maybe we have reached a crisis level in terms of wrongful convictions.
Let me make one quick point on that. And to say there have been hundreds of exonerations on death row, I think confuses an innocence-based exoneration versus procedurally based exonerations that may or may not call into question innocence. And another reason a lot of people have moved off death row is the Supreme Court has constricted the category of individuals who are eligible for execution people with low IQs, age. Anyone who committed their crime at age 17 is now automatically off the Texas death row. So I think you have to look at those numbers with a grain of salt.
Yeah, well, there were only a dozen juveniles, who were moved off, and there have been about that number of mentally retarded people. So we're talking 25 or 30 people who were moved off for that reason, and many more who were moved off for exoneration just 2-3 weeks ago.
But the school of thought.
I just wanted to say 3 weeks ago, Anthony Graves, who spent 10 years on death row and then 4 years, in the county jail, and if it had been up to the state courts, would have been executed because he didn't get any relief from the state courts. The indictment against him was dismissed, and the prosecutor, a no-nonsense prosecutor, Kelly Sigler, said it was a travesty that there was no evidence.
But don't you think the school of thought is still out there? And I'll throw this over to Robert. That okay, maybe he didn't do that crime, but if he's gotten to this point, he's in the system, he's probably guilty of something.
Well, I'm not sure that that's how people think. I know I don't think that way. I think that a person needs to pay for the crime that they did. Mm-hmm. And if they didn't do a crime, then just because you think that they may have is not a good enough reason, actually. I think one of the things that you have in juries, you still have juries. Juries are made up of human beings. Human beings make errors. And all we can do is to try and get the procedure correct as best we can so that you don't have any of these so-called wrongfully convicted persons. I just think procedurally you're going to still have problems with prosecutors who may be trying to get reelected. Who knows? When they seek a death penalty and they want to try it. And getting back to one of the points that we were talking about with the case here in Houston, I suspect that if he gets capital punishment, they make a decision, I suspect that Judge Fine will allow them to present their evidence at that time, from what I see. Mm-hmm. That would be my guess, and that's all that is. But, but you got to get there first. And once you get there, which I think you brought up, you got to get there first, and once you get there, if there is pose of whether you have a death penalty or a life without parole. Right. I think the evidence will be presented.
Just to switch gears a tiny bit before we run out of time, Texas has such a huge number of executions that happen in our state. Are we just harder on crime, better at finding the guilty people, or are we just trigger happy?
Well, Texas certainly executes more people than any other place, even when you adjust for per capita. Virginia's close. It used to be close when you adjust for per capita. But in terms of new death sentences, Texas really is like the rest of the country. I mean, death sentences have dropped all across the country, but they've dropped in Texas too. And so I think that it's a question of what you look at. Are you looking at the number of people who we execute? And Texas continues to execute way more than any other state. In the last few years, Texas has been responsible for about 2/3 of all of the executions nationwide. And in that sense, there's something special about Texas. But if you look at new death sentences, I think Texas really looks like the rest of the country.
Gentlemen, anything else on that?
I would say it's a little bit inside baseball, but the appeals courts that hear Texas death penalties are not as persuaded by arguments that are made about procedural defects. They're much more likely to trust the jury verdict than to try to relitigate the case in the Court of Appeals or second guess the way the jury weighed the evidence.
Now, I know that Dallas County has a death penalty review team. Is that something all of the counties have? Is that something unique to Dallas? Is that something that their DA is just...
That's unique to Dallas. When Craig Watkins was elected district attorney, he hired a criminal defense lawyer, a man by the name of Mike Ware, who had been involved in the National Innocence Network and so had some expertise at identifying cases where they thought they might have convicted an innocent person. And so I think part of the reason you've seen so many exonerations from Dallas County is because the Dallas County District Attorney's Office has a part of its office that is designed to look at those cases. And now the Harris County DA's office does too. But that brings us to the second difference, which is that in Dallas County, they kept all that evidence. I mean, they've kept that DNA from cases from, the 1970s and 1980s. And we're all familiar with problems that we've had in Houston and in Harris County with keeping evidence and keeping it organized and keeping it preserved. And so there's simply less raw material with which to seek exonerations in Houston and Harris County than there is in Dallas County.
Aaron, you look like you wanted to say something.
Well, I was just going to say that we're really having a policy discussion here about how many exonerations are real exonerations, how good is the evidence, that kind of thing. And to me, that's exactly the kind of thing that a community gets to decide in democracy. They get to weigh that evidence. If the community may be more conservative and places a lot of value on punishing the most heinous crimes, then they may want to maintain the death penalty. If the community, as many as 15 or so states throughout the country have decided that there's too much risk and they're willing to forego the death penalty option, then they can do that. But I guess my main point is that this is not something that one judge or 9 judges should be deciding, because it's really beyond the capability of judges to figure out whether something like this is morally proper, is basically what it comes down to.
And I wanted to go to Robert and give him the last word, but they tell me I am totally out of time. So we end there. I thank you all for coming in today, and I hope you'll come back and join us again should this come back into the news. Each week we invite you to visit our home online at HoustonPBS.org. Simply click on the local programs bar, pick Houston 8, and you can join our online community. There you can read about the guests, learn more about the topic, and even watch past episodes. But that does it for us tonight. Until next time, I'm Ernie Manous. Thank you for joining us. Good night.